Today is June 17th, 2024. I'm going to cover today in my daily journalistic update the Respondent answering brief, and this message goes out to the media. In Louis Brandeis's day, when he was confirmed for the Supreme Court in 1916, they would have called the media today the kept media, because they were kept by the railroad barons, by William Randolph Hearst, by John D. Rockefeller. And so today what we call the media is we call it the state-run media. However, I think this goes out to all media representatives because this concerns you. Whether you like it or not, or you like me or not, I am a journalist. And what I do specifically is I film police when they pull someone over or in their official capacity, any place, anywhere they are. So this must be addressed. And so this goes out to the mainstream media, to the regular media, to the state-run media, to the traditional media, whatever you want to call yourselves, because I am the new media, and I will continue to film police because that's what my journalistic endeavors bring me to be. So this is an answer to my appellate, to my appeal brief, and it's a respondent's brief from Stephen B. Wilson and Alexander Chen. It starts off on page 1 where it gives the statement of the case. And you can read down page 1, March 15th at 4:30 p.m. It was 2:30 p.m. And then it goes down to the statement of facts at the trial on March 15th, Las Vegas Metro Police Officer Brandon Bork at a traffic stop near 4155 Grand Canyon. He was in a car. He pulled over a woman. Next page, page 3, she seemed a little bit confused. Bork asked the driver for identifying information. And then it says, appellant then approached the driver and began speaking to her from roughly 5 to 10 feet away. That's the first lie right there. I have filmed hundreds of police in over 30 states in America, and I have never gone within 5 feet. That's not true. One time I walked up to a stop, and I was actually right by the passenger side door, and when the cop said to me, "You're too close," I looked at the driver's side door, and passenger door, and I said, "I'm so sorry, officer," and I stepped away because I was too close. That's the only time in the history of me filming cops that I've been within 5 feet. I'm always at least 10 feet away. It's a lie. So if they'll lie about me, state-run media, traditional media, then they'll lie about you, and you're next. At that point, Officer Bork exited vehicles and ordered the appellant to back away. Now we go down to the second paragraph, and it says, instead of backing away, appellant simply continued to argue with Officer Bork. That's not true. I informed him that I was a constitutional law scholar and a member of the press, and I'll be filming this interaction. And then it goes on to say, Bork further explained he was trying to get the appellant to back up approximately 21 feet for safety concerns for everybody involved. He explained that backing someone up to 21 feet so he can continue to do his job without interference is commonly taught in training. But it's not a code, statute, law, or ordinance. It's simply not. So they're saying things in here that are fundamentally untrue. The next paragraph down says, Officer Bork was concerned for his own safety as well as the driver's safety. He did not know anything about the appellant or what his motivations were, or if the appellant was armed. No, but what he did observe is that I was filming the interaction, that I informed him I'm a member of the press. And in the history of people filming the police, they've never been filming the police and pulled out a weapon and shot the cops. So let's get reasonable here. And then the next paragraph down, it says, it says, during Officer Bork's interaction with the appellant informed Officer Bork that he was a member of the press, as I have 2 cameras, one actively rolling. On the next page, page 4, it says, and here's where the lies really begin to pepper up. Third line down, first paragraph. Appellant refused to go in front of the patrol car as he continued to film. Officer Bork attempted to escort the appellant over to the patrol car, but the appellant swatted his hand away. Officer Bork then grabbed the appellant by the shirt and spun him around so that he was in front of his patrol car. Lie after lie after lie. Bork reached his hand out to me. I put my hand up in front of my cheek. My hand was maybe 6 inches away from my own face because you have to protect yourself at all times. And when a hand is coming in at you, it's a natural reaction to put your hand up in the air. Bork's testimony will even say that he did not believe I was trying to fight him or attack him, that I simply put my hand up because there was a hand coming at my face. It's a lie. I didn't swat away the officer's hand. That's not true. That's false. If they'll lie about me, traditional media, then they'll lie about your reporter next. And then it also continues to lie to say, once in front of the patrol car, I walked 30 feet to go in front of the patrol car. Appellant also testified at the trial and explained that he films police officers for a living as a member of the press. Appellant said he was only willing to take a couple steps back in order to move away from the stop. Appellant stated that his understanding of obstruction, it was a physical act that you have to get in the way. That's exactly correct, and that's clearly defined in Wilson versus First Judicial District Court, where they define obstruction as willful intent or the intent to hinder, delay, or obstruct. My intent was to film the police. Now we're the fourth paragraph down. Appellant stated that when ordered to back up, he backed up a foot or two and was at least 10 feet away. When the officer explained that the driver deserved privacy, appellant instructed Bork that he was to go get in his car, little doggy, and write his ticket. So I told him to go do his job. That in no way obstructs him. He could have went and done his job. The last paragraph, and this is where the argument begins. It says, now this is the big one, and for traditional media, I want you to really keep up with me here. Appellant argues that his conviction must be reversed based on his First Amendment right to record Bork's traffic stop. When appellant had a First Amendment right to record the traffic stop, appellant did not have the unfettered right to record the interaction in the time, place, and manner that he thought he was entitled to film. Okay, so what time is it? 2:30 in the afternoon. What manner is it? I'm holding a phone up announcing that I'm a member of the press. What place are we in? We're in a public place, in a public parking lot that's very busy, a lot of people around. I'm wearing a bright neon blue sweatshirt. Time, place, and manner is clearly established that if you're a psychopath who wants to go off and kill cops, you're not going to do it in the middle of a busy parking lot at 2:30 in the afternoon wearing a bright blue neon hoodie. It's absolutely preposterous. Time, place, and manner works on my side. Then as we go on to the next page, page 5, second paragraph down, this is really funny. I'm not sure what Wolfson or Chen are thinking by publishing these things or putting these into the Respondent, but let me just read it here. Fields versus City of Philadelphia, second paragraph down. It goes beyond protection of the press and self-explanation of individuals to prohibit government from limiting the stock information from which members of the public may draw. That works in my favor. You don't have the right to limit my information by telling me to move 25 feet back when I was plenty away. Then it goes on to mention First National Bank versus Bellotti, and it says, it is well recognized that recording police activity falls squarely within the First Amendment right to access information. It works in my favor again. And then he quotes Brasenberg versus Hayes. The right to record applies equally to the press as well as public. So now time, place, and manner is middle of the day, announced on the press, wearing a bright blue jumper, hoodie, and the cop says he's scared. So then it goes on here. Now I'm going to go down a few more lines here. I find this absolutely preposterous. And then right here it's going to say, in Zemel versus Rusk, the right to speak and publish does not carry with it unrestrained right to gather information. Otherwise, valid laws serving substantial public interest may be enforced against the press as against others, despite the possible burden that may be imposed. It quotes Brasenberg again. Reasonable restrictions on the right to film may be imposed when the circumstances justify them. So what circumstances are we talking about? What circumstances are we talking about here? We're talking about what? We're talking about middle of the afternoon, 2:30 in the afternoon. I've announced that I'm a member of the press, and he gets insulted because I called him a little doggy. The truth is that he got insulted and he lost his school. But I want to go point by point here because, and then it says the United States Supreme Court has recognized that traffic stops are inherently dangerous for cops. Well, it wasn't so dangerous. We're in the middle of the parking lot in the middle of the day. And then this is the funniest part of this Respondent brief. It quotes Turner versus Driver. A First Amendment right to record police does exist, subject only to reasonable time, place, and manner restrictions. Once again, 2:30 in the afternoon, broad daylight, bright blue hoodie, I announce I'm a member of the press. Union of Illinois versus Alvarez, the police may make all reasonable steps to maintain safety and control, secure the crime scene and accident site, and protect the integrity of confidentiality of the investigation. Yep, you're right. He could have asked her to step out of her car and come back to his car because I was more than 10 feet away and I'd already backed up a couple of feet. So then it goes to page 7 and it quotes Glick versus Cuniff, which time, place, and manner. Smith versus City of Cummings, which is time, place, and manner. And then it says, appellant was charged with and convicted with violating NRS Code and it quotes Stubbs in here, Stubbs versus Las Vegas Metropolitan Police. Much like the situation in Stubbs where the attorney argued that his actions were meant to represent his client, that he did not mean to interfere with the official duties of the officers, the appellant makes a similar argument in his intent to merely exercise his First Amendment right to video record officers and not to obstruct. However, the Ninth Circuit wrote in Stubbs, Stubbs points to no case, and we are unaware of none, holding that the right to counsel authorizes, and so it's the right to counsel, number one. Number one, stand shoulder to shoulder with police. Number two, during a traffic stop. Number three, while armed. Stubbs is not the right application of law. And then here, although the state recognizes that some of the specific facts in Stubbs differ, like I didn't have a gun, and the overall principles remain the same, no, they don't at all. Because, now remember, in Wilson versus First Judicial Court, it says clearly that I have to have the intent to hinder, delay, or obstruct. I don't. I'm a First Amendment auditor. I film police. Now, I'm going to get into some more things here because then it goes down to quote Glick versus Cunniff, fourth paragraph down, page 8. Glick versus Cunniff, to advance his argument, he was inappropriately arrested for filming the officers. However, Glick is distinguished from this case because the individual filming was in no way interfering with the officers. I wasn't interfering either. How is telling the cop, go get in your car and write your ticket, little doggy? How is that interfering with him? I told him to go do his job. I didn't tell him I'm going to punch you in the face if you go back to your car. Those are fighting words. That's also mentioned in Wilson versus First Judicial Court. It says that fighting words are protected unless you're using threats, which I did not do. Next paragraph down, page 8. The difference here is the appellate was actively interfering and obstructing. No, I wasn't. And it's clearly defined by the Nevada State Supreme Court in Wilson. And then it says, and refusing to back up. I'm not obstructing because of where I'm standing over 10, 12, 15 feet away as I slowly backed up foot by foot by foot. It's absolutely ridiculous. And then it goes on to quote State versus Beckham on the second to last paragraph. A person must not be detained longer than necessary, and this is no longer than 60 minutes. So Bork had 60 minutes to tell the woman, come back to my car and let me deal with you here, because she doesn't have any expectation to privacy in public. Here's where the lies really begin. The very last line on page 8 into page 9. Listen to this. And so this is for the traditional media. It's me right now. It could be you next. However, appellant's conduct, which is seen on the body-worn camera, was preventing Officer Bork from carrying out his official duties in an orderly and safe manner. Really? By me standing there and filming him, telling him I'm a member of the press and go do your job, little doggy, that somehow obstructed him from doing his job? That's preposterous. Now on page 9, here's where the lies really double down by Wolfson and Chen. Appellant was incredibly aggressive and argumentative with Bork. In which way was I incredibly aggressive? I was the only one who had my head on straight that day. The rest of those cops were violent and brutal and hurt me. I had to get surgery on my hand from what Sandoval did to my hand. Appellant was incredibly aggressive. In which way? The wind was blowing about 20, 25 miles an hour. You had to raise your voice to be heard. And all I told him was go get in his car, little doggy. Those are not fighting words. Those are stress testing my First Amendment right. I'm a First Amendment auditor. And then Chen and Wilson go on to say, again, the issue here is not whether appellant had a right to film the encounter. Bork even told him he has the right to do so. However, appellant did not have a right to ignore or resist the reasonable commands that Bork gave him to record from a reasonable distance from the traffic stop. Even appellant himself testified he was only willing to back up a couple feet because he felt it was sufficient distance by his own standard, not by my standard, by every single state across America. That's the reasonable distance is 10 or 15 feet. Moreover, rather than obeying the reasonable commands, those were not reasonable commands. He's not my dad. I am a member of the press. My job is to be the fourth estate and to hold police accountable and film them. Had Bork been beating on that woman or killing her, I would be deemed the hero today. But because he wasn't, then my press rights should be revoked. Appellant instead argued with him and excitedly told the officer he was not required to move. Excitedly? The wind is blowing at 25 miles an hour. You have to speak up to be heard. Instead of physically moving an adequate distance, I was already an adequate distance away. Appellant instead told the officers to go get in your car, little doggy, and write your ticket. So how did that stop him from doing exactly what I said? The result of the appellant arguing and refusing to obey the commands was that Bork's investigation into the traffic infractions was being willfully hindered, delayed, or obstructed. No, it wasn't. No, it was not. I was willfully doing my job as a First Amendment auditor. I had no intention to hinder, delay, or obstruct whatsoever. It's preposterous. This whole thing is just full of lies. Now, I'm on page 9 here, second to last paragraph. Furthermore, although appellant believed that his actions did not amount to obstructing an officer, appellant admitted on the stand he did not exactly know the statute or language. You know what? It doesn't matter if I do or not, because the statute or language has been clearly defined in Wilson, where it says the district court did not have our assessment before this case, and now they do. Obstruction is a physical act. That's what the Nevada State Supreme Court said. And by the way, that's misquoting me. I didn't say I didn't understand. I knew exactly what the law was. Appellant stated Officer Bork's commands were unlawful because he's only prohibited from physically interfering with the investigation, which is exactly what the Nevada State Supreme Court said. So I'm going to jump ahead a little bit here. There's a couple more things I wanted to cover, but I've already covered them. So now I'm on page 10 here. Here, the Justice Court heard the testimony of Officer Bork and watched the video of the body-worn footage. Appellant resisting his arrest. Appellant refused to go in front of the officer's car. That's not true. I led the officer 30 feet back to his car. Then, last paragraph, appellant then struggled with Officer Bork. No, I didn't. No, I didn't, and I said on the stand, I have no intention to ever fight police whatsoever. I didn't struggle with him at all. If it was a fair man-to-man match and he didn't have a badge on, there wouldn't have been a struggle at all whatsoever. That's just a simple fact. But that's not what I did. This is a lie. Chen is lying and Wilson is lying. Appellant then struggled with Officer Bork. No, I did not. No, I did not. I've wrestled for over 30 years of my life. I love wrestling. My job is not to wrestle police on the scene. My job is to film the interaction as a First Amendment auditor. I have no intention ever to have a wrestling match with a copper. Ever. Whatsoever. So they're lying here. They're lying. And then it said here, it said, appellant admitted on the stand that he swiped at Officer Bork. No, I didn't. Did not. Put my hand up to block his hand from hitting my face. Officer Bork actually testified that he did not believe that in any way, shape, or form was I trying to fight him. So it's a lie again. Hey, mainstream media, they're lying about me. This was not what was said on the stand. You can get the transcripts yourself. I did not admit that I swiped at Officer Bork. A hand was coming at my face. I put my hand up to block my face. His hand hit my hand. My hand was less than inches away from my face. Protect yourself at all times. So then it says, it goes on to talk about resisting, but I want to get a little bit into the judicial bias here. There's several pages that I marked up here to talk about, and I'm not going to talk too much about the judicial bias because there is pending litigation. I will be filing a lawsuit for what happened. But I want to talk about a couple of things here. They continue to press how appellant cites various incidents. There was no basis for the Justice Court's disqualification in the appellate case. Appellant cites various incidents that occurred during the proceedings to support his self-serving argument that the Justice Court was biased against him. His argument of judicial bias lies in the Justice Court asking him to empty his pockets to ensure that he was not recording the proceedings. That's not true. You can hear it yourself. It's on a channel called Don Andre Investigations. The bailiff came over and harassed me before court for a good 5 minutes and then went back and had a talk with the judge. Then the judge came out and said, I'm not going to be a part of your YouTube channel, meaning that she had already formed a bias against me. And then I believe that the judge and the bailiff colluded together, and she said, let's search him before the trial begins so that it would trigger me. And that's what I'll be suing over. You don't have a right to search me. I already went through the metal detectors. I'm no threat to anybody. And then it said, appellant did not seek... And then, of course, it goes on to say how I called the bailiff a pig. He argued he was chastised by the court because they called the court martial a pig. I did call the marshal a pig because he behaved like a pig. He treated me unjustly. He treated me like a bully before court began. And then when he came over to illegally search me, he was jerking my pants pockets out, ripping my jacket around. And then it said here, next paragraph down, appellant did not seek to have the Justice Court removed from his case, disqualifying the judge's way by failure to timely assess that a court should be removed. That's not my job, that's my lawyer's job. He should have immediately called for a mistrial. The moment she said, I'm not going to be a part of your YouTube channel, the bias was clear. The moment she had the bailiff search me, the bias was clear. I'm not a trained lawyer. So that's why we put in here for ineffective counsel as well. And then it says that, and somewhere in here, I don't know if this is the exact page, but it says, then the court convicted me beyond a reasonable doubt. You mean the biased judge convicted me? No jury? And then she put me in jail? There's going to be a payout here. There's going to be a big payout here. So now I'm on page 14 here, and I'm just past here. I'm on number 3. Very top of it, there's A, C, D, and then number 3. It says, a judge upon the judge's own motion may disqualify himself or herself from acting in any manner upon the grounds or actual or implied bias. She was completely biased. And in my appeal hearing, my appeal bond hearing, she even said, have you seen his videos lately? Meaning she was going outside the scope of the case. Judge Ann Zimmerman will face a federal civil rights lawsuit. That's a fact. Judge Ann Zimmerman will face a judicial complaint. And that's what I can do. And she will face the media for the rest of her life. So then it goes on to say here, now I'm down here, it says, therefore, I'm just past those little subsections here, and then it goes to the bottom, ID at 650. Therefore, a defendant's bare allegation of bias is not sufficient to overcome the presumption that the court is not biased. It's not my bare allegation. It's plain as day. You can see it on video. Unless they show the judge has closed his or her mind to the presentation of all evidence. Cameron versus State. Well, when we went to the appeal bond hearing, the judge didn't want to hear anything that was going to be presented in the appeal bond hearing by my lawyer, Chris Oram. She said, no. All I wanted to do was say I was sorry for name-calling during a legal proceeding, because that's not the place to do it. Even if the bailiff was acting like a pig, that's not the place to do it. This court is supposed to be a place where we find justice, not where we hurl insults at one another. On page 17, second to last paragraph, third or fourth line down, appellant's trial counsel filed a bench memorandum which included law that was relevant to his First Amendment claim. So my First Amendment claim was never considered. She never considered that I was a member of the press. And then it says, inclusion here, on page 18 in the conclusion here, the evidence in this case supports the justice case's verdict that the appellant had violated obstruction and resisting. Although appellant wants to make the case about the First Amendment, his actions that day were not at all about individual rights, and instead were a deliberate attempt to obstruct, resist, or delude the officers, which is completely inherently false. I just want to comment one more thing on the judicial bias part here, where this Chen and Wolfson are going to try to claim that I agree with the judge. I want to comment on this real fast. So just one more comment here. On page 15 here, when we're talking about judicial bias, Judge Ann Zimmerman says here, and they quote her, when you say he doesn't wish to engage in wrongdoing, it seems to me from observing him in the video, he wants this. He wants to get arrested. He wants to get in an altercation with police officers. He welcomes this. This helps his YouTube channel. He called the officers here in my courtroom today pigs. He called, and he's nodding his head up and down, and the defendant says, I agree. I was mocking her because she had run a kangaroo court. She had let her emotions run amok from beginning to end. But there's tells in here. So just so you know, before the trial began, the first bailiff came up and decided to mess with me, and then the second bailiff, his sergeant or whoever she was, came up and she decided, and it says here, he welcomes this. He called the officers, more than one, in my courtroom today pigs. That's not true, unless, of course, they conferenced before the court trial began. Because I called the bailiff who snatched the phone out of my hand and searched me, I called him a pig. But the other little copper in there, any interaction that was done with her was done before the trial began. She was biased from the very beginning. I was mocking Zimmerman because she's testifying for me. When you say he doesn't wish to engage in wrongdoing, when you say he doesn't wish to engage in wrongdoing, I'm a First Amendment auditor. I'm not engaging in wrongdoing. I'm engaging in filming police interactions. That's my job as a member of the press. That's what I do. That's what I do for a living. I film police. Just like someone runs out to get a soup, whether there's an earthquake or a bridge that collapses or some famine or some disaster from a tornado, what I do is I film cops. You say he doesn't wish to engage in wrongdoing. You're exactly correct. I don't wish to break the law. I wish to be engaged in a First Amendment protected activity. He wants this. He wants to get arrested. Well, to the court. I have over 500 interactions with police. The only place I've ever been arrested for filming cops is in Las Vegas, Nevada, and I don't want to get arrested. So at this point, she's making a mockery of the court. She's running a kangaroo court, like a clown, like an absolute clown. And so I have every right then to mock her and say, okay, I agree. She's up there testifying on my behalf. It's a joke at this point. Clark County will have to pay me out. The judge should be admonished for this. I wish she could get fired. And he's called my officers pigs. Your officers? It's a joke. This entire response to my appeal is a joke. Chen and Wolfson lie in this over and over and over. That copper, when I said, go get in your car and do your job, little doggy, he could have done exactly that. Police officers on any scene are supposed to be able to take a certain amount of significant pushback from the public. There's two specific words I can't remember them off the top of my head. So if you're the traditional mainstream media and you're listening to this, when they came for the communists, I said nothing. When they came for the socialists, I said nothing. When they came for the trade unionists, I said nothing. When they came for the Jews, I remained silent. When they came for me, there was no one there to speak up for me. We want to go back to the Sedition Act of 1917, the Espionage Act of 1918, and you want to have those kinds of things upheld? Well, if you allow Wolfson and Chen to print these kind of lies, that I angrily and that I excitedly said these things to the copper. No, I didn't. I didn't angrily say anything. I was never mad. Over 500 face-to-face interactions with police. You've never seen me get mad one time, ever. I'm allowed to redress government in any form I choose as long as I don't use fighting words. So if the mainstream media, the traditional media, the kept media is going to remain silent on this, who's going to speak up when it's due? And that's my daily update for today, June 17th, 2024. We're 23 days away from the appellate hearing, from the appeal hearing in the district court in front of Judge Michelle Levitt. This case should be overturned. The Nevada State Supreme Court has clearly identified that obstructing is a physical act, and it is protected. Unless you're using fighting words, you cannot be charged with obstruction, and I did not obstruct. I did not go there with the intent to hinder, delay, or obstruct Bork or anybody else there. I went there to film the interaction. Time, place, and manner is clearly defined. 2:30 in the afternoon in the middle of a busy parking lot, wearing a bright blue hoodie and announcing out front, I'm a member of the press. I started filming with 2 cameras by the time the interaction was done. It's preposterous on its face. And Wolfson and Chen, you quoted a bunch of cases that are on my side. These cases absolve me. These cases prove that I'm innocent. You even quoted Wilson in here. This is preposterous. All right, I'll let you guys go. Thank you so much for your support. To Team DLV, thank you for writing me letters, for getting me those iCare gift packages. I really appreciate it. For donating to my GoFundMes, I really appreciate it. We don't stop under any circumstances, under any conditions. Alan, I appreciate you, man. Thank you for putting money on my books. You did it. David, thank you. I appreciate it. Cope Doggy Dog, thank you. I appreciate you, man. So many of you. I got your letters. I got your letter, April. I got your letter, Linda. I got your letter, Carl. I'm not going to remember everybody's letters, but I got a bunch of letters here. Keep sending them. I really appreciate it. All right, I'll let you guys get the flock out of here. 23 days. Put it on your calendar, July 10th. And let me just say something to the court here. If you ban my family and my friends from coming in, listen, you're already getting sued. I'm suing them over not letting my family and friends in the court for my appellate bond hearing, for my appeal bond hearing. They denied my people access to the court, and the bailiff or whoever it was at the door lied and said, oh, his hearing has already been heard. No, there was a dozen people standing outside, and 8 of those people are signing onto the lawsuit. You cannot ban people from coming into my public hearing. There's no danger to the court from me. That's preposterous. It's just an absolute despotic government and this dog shit court system in Clark County, Las Vegas. It is absolutely dog shit, led by the kangaroo court queen herself, Ann Zimmerman. So she's gonna have to face a federal civil rights lawsuit for what she's done. That's all I can actually do. So, all right, I'll see you guys on the next one. I'm not sorry. I'm not sorry one bit. I'm only sorry that I name-called in court. Court is not a place to call names. Court is a place to try to find justice and resolve differences. So, all right, I'm going to get the flock out of here. I'll see you guys on the next one. Later, Gators.